Sir, there is one question from Mr. Satyendra.
Yeah.
He asks that, sir, if I would like to have some clarity and explanation with respect to dominance per se is not illegal, but the abuse of the position of dominance is illegal.
See, I think this is a competition law question, purely a competition law question, because we know that the abuse, the dominance in, for example, if you take Geo or if you take Reliance, if you take any Indian, so-called Indian multinationals company, I would say that Indian multinational companies. So they may dominate. They may dominate maybe because of some new technology which they may be using. Because when the data become very cheaper because of the entry of Geo, and we all accept, and all the players in the market at that point of time, they lost their markets. So some new player came. So change in technology. So as you know, change in technology as one reason for the dominance in the market. So all the players, they went to the sectoral regulator. You saw that the cases. They went to the telecommunication regulator. So telecommunication regulator said, yes, there is no abuse of dominance. There may be dominance by using various means. That is actually true with regard to all business in the market. So what is the objective of competition law? Competition law objective is very clear to see that there is more competition in the market. Not the only concern with the process of competition, not the competitors. So you can very well dominate in the market. So I already said that the Microsoft have 90% of the Indian market is dominated by Microsoft. But that is not bad. But at the moment, if you see that they are started abusing their dominant position in any way. So if somebody say that, oh, if you purchase one volume, I will give you for a lower price. The moment you purchase 150 volume, so I will increase the price. So we never had this in the the history of business. That if somebody purchases one piece, less price. Somebody purchases more pieces, more money. So it is other way around the story. So dominance can be subject to competition law. So anyway you dominate, we don't have any problem. The moment you abuses in the name of forming cartels, in the form of tying arrangements, in the form of exclusive agreements, imposing restrictive conditions, this is abuse. So anti-competitive practices, one side, abuse of dominance in the market is on the other side, the two hands of competition law. So the moment dominance per se allowed in the market. So if you have a new technology, a new product, a consumer choice is towards you, definitely you are going to be the market leader.
Thank you so much, sir. Sir, there is one more question from Mr. Satyendra. Sir, if a company A has charged excessively in country X for its product and less in country Y for the same product, do such activities of company A amount to abuse of position of dominance or not? And what would be the jurisdiction if it is abuse of dominance and some remedy has to be sought?
See, it is very clear that this is another area of practice. So this is, under another WTO agreement, neither under TRIPS agreement nor under the competition law. That agreement is known as anti-dumping agreement. If you sell a particular product, a less than its market value in your country, if you are selling it for a lower price in a foreign market, then these countries can impose additional duties which are known as anti-dumping duties. So you cannot insist anybody to sell a particular product in any one country for a particular price. You sell it for a lower price, you sell it for a higher price. Doesn't matter. The competition law is nothing to do with it. But if you look into the antitrust law of United States, you can see we clearly says that if any American company is doing any anti-competitive practices or abuse of dominance outside the territory of the United States is also actionable in the United States. So there is a extraterritorial application of competition law in the US. But in India, we don't have that particular provision. And also in India, so I would very clearly say that this doesn't have the application of competition law. Definitely, if somebody is selling for a lower price, you can impose anti-dumping duties to the extent of lower price. So it is known as the margin of dumping. So not the competition law. So pricing is one aspect. Higher pricing, definitely the competition law can look into, but lower pricing, the competition law cannot look into.
Sir, there is a question from Mr. Palgiri Nityakumar. If the price of a product is set below the manufacturing cost to drive away the competitors from the market, is it predatory pricing and is it abuse of dominant position?
It is clearly predatory pricing. So the term itself is saying that it is a predatory pricing, because if somebody, the objective of, again, this is not in the domain of competition law, it is dumping. So dumping a particular product in the market for a lower price, predatory price, to drive somebody out of the market, then definitely it is the predatory dumping. So this is nothing to do with the competition law. If you want to put under competition law, as I said that unreasonable pricing will come under the competition law, but lowering prices will come under not abuse of dominance. There is no dominance. Again, the market share you have to look into for the abuse of dominance. So and also the market, definition of market also changes from time to time. So which market also you have to look into. So here also abuse of dominance never comes. So again, it comes, definitely it is a predatory pricing. Predatory pricing also to deal with under the anti-dumping law, not under the competition law. If you ask me whether it is will come under the abuse of dominance, no, it is not going to come under the definition of dominance. If I can sell a particular product for a lower price, how I am going to dominate? So these are the two issues. Pricing is different from domination. But because of dominance, if I charge higher prices, then definitely it will come under the definition of dominance or abuse of dominance.
Thank you so much, sir. Next question is from Dr. Nagalakshmi. To what extent there is reasonableness in the apprehension of IPR holders about the possibility of confidentiality breaches in relation to the information shared by them to CCI authorities? If scope for breach exists, how could it be handled?
So you see, in the recent case of Ericsson case, this issue was raised by Ericsson. And they argued before the Delhi High Court about forming a confidentiality club. So what was the argument? The argument was that the confidential, whenever there is a high technology area case comes, the court should constitute a technology club, which includes very few people. That means probably the lawyers of both the parties or some very important, the officials of the companies. But then there is no provision, neither in the Indian intellectual property law nor in the competition law to keep this information shared to the CCI authorities. To what extent it is the confidentiality breaches. So what are the penalties for confidentiality breaches? So we have other laws like Official Secrets Act, but there is no provision in these particular institutions with regard to confidentiality breaches. So, but the companies insist for forming the confidentiality clubs. So the confidentiality clubs, definitely there will be a written agreement between the parties not to disclose. So we know that our legal system, and we believe in the court system in India, and we give the documents to the courts. But if somebody is leaking it to the other, especially in the case of technology, so what is the remedy? Yes, the remedy is in common law, the remedy is in contract law, the remedy is in penal law. We don't have trade secrets law. We don't have trade secrets law. We have Official Secrets Act, right? So we can use, if we have a trade secret law or we have a confidentiality breaches in violation of agreements. So your remedy is under the common law, under the contract law, and also the penal provisions. Other than there is no provision in intellectual property law nor competition law at the present. Right?
Thank you so much.
How it is handled? So definitely the government to take a policy decision. on the high technology areas.
There is next question from Mr. Mohan Rao Hanchate. What are the grounds for declaring misusing of dominant position amounting to anti-competition in case of patents? Whether IP rights are absolute rights or are they subject to certain reasonable restrictions?
I already, answered this question through the Amir Khan case. So the court very clearly said that maybe bundle of copyright includes a bundle of rights, but it is not absolute at all. So, and also you can look into section 19 of the Competition Act. What are the, what do you mean by exactly the grounds on which appreciable adverse, what do you mean by exactly appreciable adverse effect on competition, right? And whether this is applicable to the intellectual property cases? Yes, definitely. If any of the technology holder adopts this kind of practices, but again the question is the evidence. Where we will produce the evidence? What is the evidence of abuse of dominance? Again, technology markets. Technology markets are concerned how you are going to produce the evidences. So we don't have experience of conducting these particular cases. That is why the best example is the Microsoft case, Micromax case. So for a period of 10 years almost, they fought each other. Then finally they found a solution outside the court. Because they were fighting and fighting, the cases is prolonging and there is no decision. So that is why they settled outside the court. So definitely the Indian competition law is applicable to the intellectual property cases. That is the Delhi High Court held in Micromax case.
Next question from Mr. Samir Velankar. Do IT monsters like Google, Facebook, who are super dominant, come under purview of Competition Commission of India? Google per se is facing lots of cases in Australia, France, pertaining to dominant position. In India, with respect to Google, Facebook, what is the Competition Commission of India and IPR position?
See, it is very clear the Competition Commission has already started action against Google. And now, especially with regard to the advertisements, and one investigation is going on. So I don't know what is going to be the result, but yes, we are also started investigations into certain, the practices of Google. So everybody knows that Google is in a very dominant position. So what will be the result? We have to wait and see. So what is going to happen to whether the Competition Commission is going to take any action against Google? I'm very sure that yes, there must be some kind of actions to be taken against Google. Because everybody knows that yes, there is abuse of dominant position in the Indian market as well. So, but at the same time, yes, definitely, I'm very clearly saying that CCI has ordered an investigation in June 2021, but so far there is no result as such. So they are saying that the Google is abusing its dominance in the Android operating system. India's, the smart television market. There is other allegations with regard to the CCA, details of Google payment. And then again, there is, the Google investigations, CCA investigations against them for the advertisements. So there are so many investigations at a time is going on with the CCA. So what will happen? Definitely, if we can look into the cases from other jurisdictions, yes, they have to take action. Whether they take action or not, we are not sure, because this is India, right? As for example, I told you the Micromax, the Microsoft case. US huge millions penalty, EU 700 million penalty, India no penalty, because the CCI couldn't find any evidence of abuse of dominance. Yes, they said that yes, Microsoft have 90% market share, so they are dominant. They are dominant in the market, but no evidence of abuse. So the question is how you are going to find out evidence of abuse by Google. So we presume that yes, some action may be taken against Google. Okay, so definitely the Google lawyers also may be watching our lecture. So they will be prepared to fight against the Competition Commission of India.
Sir, next question is from Ms. Srinidhi. Sir, SEPs have a crucial role to play in developing economies like India. However, SEP jurisprudence is very nascent in our country as compared to EU and US. Courts have not even touched upon definition of FRAND or method calculation of FRAND royalty rates. Will the situation get better with 5G? What can be done to address this issue?
See, as I told you that I have gone through all 22 cases only with regard to SCPs. So I have sent the article to the Journal of Intellectual Property Rights. I don't know what they are doing. So I thought that this is the best time to come out with some kind of jurisprudence, some kind of guidelines by the competition authorities at this point of time, or even the court can come out with guidelines. In Micromax itself, there should have been come out. But now there are a lot of cases. Now there is Google cases and Huawei case, and the China is trying to impose these particular provisions in Chinese court. And in one of the cases, it has happened. So Huawei went to Wuhan court. Yeah, Wuhan is very famous now. I don't have to explain. They went to the Wuhan court against another Chinese company in India, and they come to India with the Wuhan court judgment for enforcement. So they are not able to get a judgment from Delhi High Court. So they went to Wuhan court, they get a judgment. They came to Delhi High Court for enforcement of judgment. This is nothing but completely abuse of process of law. So you didn't get a judgment from Indian court. So you went to your own country, you get a judgment, then you come to this country and ask the same court to enforce the judgments under the enforcement of foreign judgments under the provisions of CPC. This is abuse of dominance. So SCP jurisdiction, I think probably the Indian courts have to look into other cases. In my article, I have dealt most important cases from the US jurisdiction and EU jurisdictions. So I think that in some of the coming issues, Journal of Intellectual Property Right may publish that particular article with regard to SCP. That is only with regard to SCP jurisprudence. Yes, there is jurisprudence in US and EU. Indian courts have to look into, and they have to come out with some guidelines with regard to, especially with regard to the standardization patents and front tapes and also the royalties.
Next question is from Mr. Ali Sher Shah. Sir, can we say that competition law provides good checks and balances for IPR laws as far as economic efficiency of market is concerned, and also it prevents evil effects of IPR laws?
See, as I told you that these are, everybody says that yes, the competition law is against intellectual property law. I told very clearly from my presentation from the very beginning that I always argue that these are two different set of law. The objectives are different. And the intellectual property definitely gives a monopoly right for a limited period of time, but don't abuse it. So when the moment, if you are found to be abusing these intellectual property rights, the competition law will be applicable. Yes, competition law is an antidote to the abuse of intellectual property rights. So to that extent, yes, to that extent, intellectual property versus competition law. Otherwise, I don't think there is any conflict between these two laws, because these two laws operate in two different places, two different aspects.
There is one question from Mr. Purushothaman R. Sir, charging excessive prices on life-saving drugs is within the ambit of price control, and CCI has jurisdiction over such matter. Even Section 4 of the Competition Act 2002 talks about abuse of dominant position. How should we construe this?
Abuse of dominant position is something different from excessive pricing of medicines. There is another pricing authority in India. There is another authority, exclusively another authority under the drugs and cosmetics act. So the pricing authority of India, which fixes prices. So if somebody is saying that there is excess pricing, yes, you can go to the authority and make a complaint, and they will decide the price. And definitely, their jurisdiction also limited to life-saving drugs. So we know the famous cases, the famous case of 3D. So the multinational company is fought in the Madras High Court. So if it is a life-saving drug, and definitely you cannot charge too much in the name of intellectual property. But I don't think that competition law is applicable in that particular case, because excessive pricing is definitely is a part of competition law. But with regard to drugs, yes, the special law will prevail, not the general law. But to the extent of abuse of dominance, the competition law is applicable. But pricing of medicines, I'm very sure. So we have a pricing authority. They will look into the particular matter, not the competition law. There is no applicability of competition.
Yes, sir. Thank you, sir.
I think we will stop. And
yes,
definitely, sir. I would like to thank Reddy sir and other people and all those who are asked questions. You can send questions to me directly. So I would like to definitely thank. It is very nice, Reddy sir, to organize this program. And hope that you will organize more number of programs, and future also we will be able to come, and participate in your programs.
Thank you, sir.
Now I request Professor Reddy sir to please take give.
So thank you very much, Professor Raju. And in fact, it has been a wonderful discourse. I never missed a single word. And now I don't want the participants to lose such, delicious taste of the, admixture of both competition law and intellectual property rights. You touched upon so many issues, including the Micromax, Sony Ericsson, Microsoft. Phenomenal. And it has been a great experience for all of us. We learned a lot of things. And hope, as you rightly said, it is the age of survival of the fittest. So NLUs may have a little advantage, but at the same time, when there is a level playing field, it is only our capacity and the efficiency which will stand us in good spirit, good stand. So thank you very much on my personal behalf. We wish to have many more such programs, but this is only in the series, the lecture number 1 from you. We expect many more for the larger interest of the IPR community. Thank you very much.